I guess the subject did not draw that big of a crowd because perhaps people don't really know what it means and why people get so passionate about it these days. And I don't know if you have seen here and there news reports about the clash between exercising IP rights, like copyrights and database rights, and the possibility, or not, to do some text and data mining. And it has really created a huge controversy at the European level in the last few months, especially since March, well, February, March, where the scientists in Europe, and mainly UK, also in the Netherlands, but also through the voice of big scientific journals, scientists have been really crying out because it is impossible for them to make text and data mining and to use the databases with which they normally work. They can't use those to really generate knowledge from the big data. So this is one article in Nature that really drew the attention in March about the clash over text and data mining. And, well, in the coming minutes, therefore, I'll draw a portrait of, well, text and data mining. You all know what it is because you're doing it. And this is the center of digital humanities. You know what text and data mining is. But, well, you may or may not know, we should examine together what it means from a copyright and database right point of view to do some data mining, and then impact of these rights, the IPRs, as intellectual property rights, meaning copyright and database rights, what their impact is on text and data mining and the current debates. So I start off, well, I needed for myself to give myself as a jurist a definition of text and data mining, as again, you all work with the tools, but as a jurist, I don't yet. So, of course, text and data mining are both based upon statistical pattern analysis of content. So a robot will examine huge quantities of data to filter out, according to a specific query, all the knowledge that the researcher is looking for. And it can be either text mining or data mining. And there's a difference between text, I learned, which requires syntax analysis or syntactical pattern recognition next to statistical methods of co-occurrence of terms, which is much more technical, I would say, than the data mining, which is a more general term and can cover interpretation of data as numerically expressed attributes, usually based upon algorithmic pattern recognition. I guess you all know what this means. For a jurist, that's a bit more obscure. But there we go. What's the problem? And the problem is that, well, text and data mining, abbreviated as TDM, involves access to and usage of articles in bulk. So it involves using data, and the data can be in the form of an article or pure raw data. It's any huge collection of articles or data, so accessing it and using it to generate the knowledge based on this filtering out. And this, therefore, in copyright terms, involves, well, can involve either the copyright or the database, right? And I'll give you a portrait of copyright, what copyright entails and what database rights entail, and then we'll join again. Now, this might be common knowledge to you all already, but you all know that, at least I have someone who doesn't already know, so I'm very happy. Good. Well, I'm just checking. I mean, it's important for someone to give a lecture and to know that you're not telling all commonplace things to most of the people. So I'm happy. I'll tell you what copyright entails. Now, the subject matter of copyright is well, and this here would be nice to have a pointer, because I could tell you, actually copyright protects the expression of an idea, but not the idea itself. So facts are excluded from copyright protection. But even talking about expression of an idea, copyright will attach to expression as long as it's original. So there's a criteria of originality under copyright. And now, in the respect of databases or corpus of knowledge, you can see it in two different levels. You can see it globally as a compilation. And the compilation as such, as a gathering of data or articles or everything, will be protected by copyright if the compilation itself is original. And the originality of the compilation will probably be reflected in the selection and arrangement of the content of the compilation. Now, in the case of a big publisher, there probably is no originality in the compilation because they don't arrange and select according to originality criteria. They just gather what they produce in a big database. Now, this is the first level. When you look at the aggregate level of the database, you also need to look at the individual level of the articles. Now, articles, scientific articles, or whatever other content in a database may also be protected by copyright, again, if it's original. So articles, music, videos will be protected by copyright if they meet the requirement of originality. So meaning that a database may contain copyright-protected elements, but also may contain non-protected elements such as facts and data. So this is the subject matter for copyright. If it's original, either because it's a compilation or because it's an individual article, then the rights owner has two sets of rights. One is the economic right, and the economic rights, well, if you look at the German Copyright Act, you will see that there's a list of different rights contained in the Act, and it's much more specific than this one. But generally, you can categorize the economic rights in two groups, the right of reproduction and the right of communication to the public. And the right of reproduction that has rather been harmonized at European level, and that's any temporary or permanent reproduction by any means and in any form. So therefore, a reproduction by a computer is a copyright-related or copyright-relevant act. That you might infringe somebody's rights if you make a reproduction in a computer. Now, and the right of communication to the public is also a broad term that if you look in the German Copyright Act, you will see much more specified, but it contains broadcasting, making it available on the internet, also distribution of copies of a work. Now, this is the first part of the rights confirmed by copyright. You also have moral rights. The moral rights are, well, less important, I think, in the context of data, text and data mining, but I still need to mention them. And the right to request that your name be named together with the work, yeah? The attribution of your name with the work, or your right as an author to oppose a modification of the work, or a mutilation, etc. So these are the rights that you get when you create something original. And, well, a big element to know is that copyright, you don't need to register copyright. You get the copyright protection as soon as you create something original. So it's an automatic form of protection. And the protection lasts for the life of the author plus 70 years after his death. And that's a very, very long time. And that means that if you think, you know, of a big publisher, you think of Elsevier, or you think of Nature, or any other big publisher, they've been publishing articles of scientists for almost a century, I would say. And that the bulk, the huge, vast bulk of those articles in the databases of the publishers still is copyright protected because the protection has not lapsed yet. So only the very old works might already be in the public domain. Now, if you work with databases containing manuscripts of the 1600s, those manuscripts will be in the public domain. So those will be no longer protected. However, do remember that the individual articles may not be protected, but the compilation, if there's creative work, if the compilation meets the criterion of originality, you might have copyright protection on that compilation. So not on the individual components, but on the aggregate level, if the compilation is original. Now, there are, of course, under copyright, there are exceptions and limitations, and you might think, well, does text and data mining fall under one of those exceptions and limitations? Here I listed the three most logical limitations that you might think of when you think of text and data mining for research purposes. Now, the first one is incidental and transient reproductions. This is introduced by the Information Society Directive in 2001, and it's uniform across the European Union. And the idea behind this was that purely technical reproductions to allow a system, an automatic system to function easily, where they're absolutely temporary and necessary to execute a technical function, those should be exempted from or excluded from the scope of the copyright. And we'll see, I'll see in more details those three limitations, but this is one. The second one is the right to quote. And the third one is educational and research use. Now, the three types of limitations have all been harmonized through the Information Society Directive, but they've been implemented. You may or may not know that the directive, European directive, needs to be transposed in the law of each member state to become binding. And so the directive usually gives, contains norms that can be interpreted or transposed differently from one member state to another. So you see indeed strong differences in the legislation of the member states concerning the limitations, exceptions. The wording is different and sometimes the scope is different. So, incidental and transient reproduction. I took the text from the Urheberrechtsgesetz to make your life easier because, well, this is probably the most widely harmonized exception because it was new. So when the Information Society Directive was adopted at the European level in 2001, it was a brand new provision that did not exist anywhere before in any of the member states' legislation. So the member states could not really rest on their tradition or existing limitations or existing legislation. So they just decided, basically, if you look at all the acts, they all copied the text of the directive. So, and basically you see here, this is the formulation of the exception. But really what stands out here is that the reproduction to be exempted from the scope of the copyright needs to be really ephemeral, really transient. And there is some case law from the Court of Justice of the EU that did interpret this provision, but it's really limited. There is a bulk of case law in the member states that usually refuse the application of the exception because the reproduction was too permanent or too long-lasting to fall within the scope of this transient.
For example, when it's a library law, they scan things, but they are not allowed to store them.
No.
So you have to throw them away.
Yeah.
Then you scan it again if the request comes in again.
Yeah, and yeah. So this clearly does not fall with the incidental and transient reproduction. Yeah. So when you think of the text and data mining, when you send a robot to filter out and gain knowledge throughout the whole corpus of a database, it doesn't fit the criteria of this provision. So it clearly doesn't fall within the ambit of this provision. The provision was thought in 2001 as allowing browsing and caching, but not any caching, just really the very short-lived caching. So yeah, so courts interpret this provision very restrictively. Now, you might think that text and data mining might be a form of quotation. Well, it has been argued, but not very convincingly. If you look under the Information Society Directive, it's Article 5.3b, and quotations are allowed for purposes such as criticism or review, and then you have the conditions, provided that they relate to a work or other subject matter which has already been lawfully made available to the public. Well, that would be fulfilled. That unless this turned out to be impossible, the source, including the author's name, is indicated. Well, you have there an excuse not to indicate the source or the name of the author, and that their use is in accordance with fair practice to the extent required by the specific purpose. Now, text and data mining a whole database would probably not comply with the last criteria of the provision under the InfoSoc directive. And even worse, if you look at the Dutch text, I hope it's a bit clear enough, but especially, and there again a pointer might be useful, but the one problem would be that einzelne Werke nach der Veröffentlichung in ein selbstständiges wissenschaftliches Werk, excuse me for the accent, but meaning that the right to quote basically is to allow the author to quote inside a new work, you know. And this integration in a new work, the text of the InfoSoc directive doesn't talk about it, but the national legislation in most cases do require that a quotation be integrated in a work of scientific criticism or other forms of integration in a new work. You quote for a purpose. And the purpose is to criticize or study or announce, or depending what the formulation of the act is, but you always quote in something else. And when you do text and data mining, you don't quote in something else. There's the purpose and the...
If the purpose of the data mining is to produce a new work,
It's a step too far, yeah. Well, at least for the traditional interpretation of the right to quote. There are many authors in Europe who try to push for a more flexible copyright regime, you know, push for reform at the European level, and some people push for reform at the more national level, like in the UK or in the Netherlands. And they say, well, problem is, just ad aparté, between brackets, that the Information Society Directive contains a list of 20-some limitations. Most of them are optional, but the problem with the InfoSoc directive is that the list of limitations is exhaustive, that member states are not allowed to adopt any other limitation in their own national legislation than those that are listed in the Information Society Directive. So when you want to deal with new phenomena like text and data mining or user-generated content or any other form of use that's not covered by the list of exceptions, then you're stuck at the European level unless you try to interpret the existing limitations a bit more broadly. And that's what the scholars in Europe are trying to say, that the right to quote, or the quotation exception, should be interpreted more broadly to allow more uses than what's currently the case in most jurisdictions. But stretching the bounds of the right to quote, in my opinion, is not the solution.
Change the European legal framework.
That's my personal opinion, yes, because you can only go so far, and then the right to quote loses its original traditional purpose. So, and I think it never fully meets the needs anyway. So, now, educational use and research, that's also a limitation that is included in the Information Society Directive, and you might see here also a slight difference between the text of the directive and the text of the Urheberrechtsgesetz. Now, under the directive, you can use for the sole purpose of illustration or teaching or scientific research, as long as the source, including the author's name, is indicated, unless it's turned out to be impossible, and to the extent justified by the non-commercial purpose to be achieved. Now, this is this normal wording, and this is the normal wording you find in most of the copyright acts throughout the European Union. Article 52A of the Urheberrechtsgesetz is a bit controversial for the European Commission, at least, because it goes a bit further than Article 53A of the directive, in the sense that it allows published parts of works to be communicated. Well, I'm translating to a small group of scientists. So, and you see, this is a clear distinction. This is a language that you don't find in the Information Society Directive. And I know that the European Commission had to discuss this issue and with Germany when they implemented this provision. And I'm not sure if I'm mistaken, but this provision had a sunset clause, what we called. It was supposed to be abrogated after a while, but they keep prolonging its application. So it was so controversial that this provision was put in the Act with a certain deadline, but they keep prolonging the deadline because, well, no one hit the roof so far. I mean, there were discussions with the European Commission, but basically publishers seem to be able to live with this provision in Germany and in other countries. Well, it did not snowball in other jurisdictions. So, but if you look at it, German scientists, through this provision, may do a little more in terms of communication among scientists than what they can do on the basis of the Information Society Directive. However, even if you look at this, it still doesn't allow text and data mining, because depends how you look at the provision and how you interpret it, but to scroll and to send a robot throughout the whole corpus goes way beyond this use for the sole purpose of illustration or scientific research. Yes?
I wonder, is there already legislation on this restriction on limited amount of people? So is there a definition of how many people can get access, and when it's still restricted or not, or limited?
Same thing with the small share. yeah. How small is the share?
So I just wonder if there is already some legislation or.
No legislation. Such vague concepts, they leave for the case law. They leave for the judge to interpret what they feel in the circumstances of the case to be fair and to be the amount of researchers or the amount of a part of a work. So there's no legislation. Whether there's case law, there might be one case, but I'm not sure anymore. And at the European level, the discussion on this, on these norms usually is between what's public and what's private. There's a lot of case law from the Court of Justice about showing TV programs in hotel rooms. Now, this is totally different than what we're talking about, but the distinction here is showing a program in a TV, in a hotel room. Is this public or is it private? And so the court has spent a lot of time trying to examine, you know, when are we in a circumstance that it's private and when are we in circumstances where you can talk about public. So, and basically, constantly, the decision of the European Court of Justice is to say, well, if you show TV programs in a hotel room via a decoder, then you're broadcasting, or at least you make an act to the public, because it's unidentifiable, potentially unlimited number of people in the public. Yeah, so, but to have, this is a unique provision in Europe. 52A is unique. There's no other provision in any of the copyright acts in Europe. And so for the interpretation of what's a small circle of scientists and what's a small part, you would need to look at German case law, and please forgive me, but I didn't have time to check if there was case law on this particular one. I suspect there might be one case or two of lower instance, but not the Bundesgerichtshof. So,
just rules of thumb. Just rules of thumb.
Yeah. But I mean, in other jurisdictions, you will also have case law on, you know, how far can you. Well, not in respect of the educational use, but for quotation. In France, for example, the right to quote is limited to short quotations. And so there is case law in France about what constitutes a short quotation and when do you go beyond the bounds of a short quotation. It's slightly different, but it's the same rough distinction.
Also, that what happens when it's within a book. I mean, you have this small.
Yeah, but I mean, but if, for example, in Germany, you have a very interesting case of the Germana case. It was Bertolt Brecht's theater play, if I remember, had been reproduced quite extensively in another play. And it has gone to the Bundesgerichtshof to say, well, you know, because of course the heirs of Bertolt Brecht claim you quoted much too far for the limits of the quotation right, and basically the Bundesgerichtshof decided, well, it fit within the purpose of the play, and it was a political or social statement. And there was the right to create, Article 5 of the Grundgesetz. So he balanced all the rights involved, and the BGH came to the conclusion that it was allowed. But it's such a vague concept. You always need to see what the circumstances of a case are and how it's being argued also by the lawyers and how it will be picked up by the courts. So it's difficult, but in any case, I'm pretty convinced that text and data mining don't fall within the ambit of educational and research use. Especially if you look at other jurisdictions where you don't have the unique provision of 52A. In the UK, for example, you can make a fair dealing of a work for purposes of scientific research. And they have criteria, but a fair dealing entails that it's never the whole entire work, let alone an entire database. So, okay. Now we go to the sui generis database, right? Sui generis being of its own. It was a newly created intellectual property right, and it was created in 1996. But also through a European directive. It's a brand new right, and this protects. It's not an IP right that protects creativity. It's an IP right that that protects investment. So the criteria for protection under the database right is whether you have invested substantially in the creation, not the creation, in the collection, verification, and presentation of a database. And the substantial investment will be evaluated either quantitatively or qualitatively. So, meaning substantial investment maybe in terms of money. Did you invest a lot of money to make the database? Or did you invest or need to hire experts? You know, did it involve very specific expertise in the making of the database? And that will be the qualitative investment in the knowledge required to create. So they didn't want to narrow it only to money, but they also wanted to acknowledge the fact that sometimes to create a database you need a specific knowledge or other types of input. Yeah?
So every nature database is now part of this law, so it's protected?
Well, basically. So to come back to my two examples, you know, like publishers like Nature, publishers like Elsevier, they invest and they gather and they organize and they present to the reader. So for me, it's rather clear that they do have a database right on their databases. And if you're working, I guess, with other databases that may contain public domain works, like manuscripts of the 16th century, for example. However, if the maker of the database has invested substantially, either qualitatively or quantitatively, in making the database, he may have a database right on it, even if the individual elements are not protected. And just like copyright, database right protection is automatic. You don't need to register. So as soon as you create or you complete the database, then you have a protection that lasts 15 years from the creation of the database. And a slightly controversial provision at the time of its adoption anyway, is that if you make a substantial investment in updating your database, this on its own also is worth a 15-year protection. Now, and the thing is, now we're in, the database directive was adopted in '96. It was implemented in most countries by 98, 99. We're almost close to a 15-year first term for the existing databases. We don't have yet case law on how courts will interpret renewals or extensions of protection. But that will come in the next few years, where people will say, well, you know, that database that was released in '99, however, you know, it's almost unimaginable that the person who created the database in '99 did not update it. And so therefore the potential, and that has been pointed out in literature many, many times, is that you have a potential there to have endless protection because of substantial investment in collecting the data and presenting it and verifying it. Well, that's where we need case law on. Okay. So that's what we don't know yet, but we haven't, you know, we haven't gone through a first 15 years. Yeah, it's.
In the end, Web of Science is the whole world of science in the end, somehow, because they belong nearly all. They belong to all articles.
Well, we'll get into the discussion in a few minutes. I know you need to go, but yeah, but okay, shortly. So the database protection, what the database right gives you, it gives you the equivalent of the copyright with other terms. So instead of reproduction, they call it extraction, and instead of communication to the public, they call it reutilization. So, but the idea is the same. You reproduce and you communicate to the public, but with other words. But what it also adds is that a systematic and repeated extraction and reutilization of insubstantial parts of a database may amount to an infringement of the database right, but then the Court of Justice of the EU has narrowed this down it only creates infringement if the repeated and systematic extraction leads to the creation, to building up again the database, the initial database. So if you keep repeated systematic extraction of insubstantial part and you never build up another database, so basically it's not an infringement. So that at least. Okay, now limitations. The limitations under the database directive, the thing is they're optional again, and the only one that is really relevant is the one for educational research purposes, but it's again rather limited. And so there we go to the discussion. And Gerhard, that's my first bullet point. Rights most probably subsist in database and or content of publishers. Yes. I mean, whether you look at the aggregate level or at the individual level, aggregate level, most probably there will be a database right on it. And if you're talking about publication of articles, yeah, probably you also have copyright on the individual articles in the database. If it's a database of pure facts or raw data, then there might be database rights on, on the database if the maker of that database can show that he invested substantially, and that's debatable. But basically, all publishers, they invoke the copyright in their articles, and they're not too strong invoking the database right yet. I'm afraid that they'll use this as the backdoor arguments once we clear the discussion with copyright. Because, the article in Nature that I showed at the beginning of the talk really mentioned only copyright. And I don't understand why they just, don't deal openly. Well, yeah, they have a database, right? I'm just afraid that they're keeping it backhand to say, yeah, okay, so now there's an exception for copyright to do text and data mining, but by the way, we have a database right. I'm afraid of that because, well, they could be known to do that. Anyway, so second conclusion is exceptions and limitations are hardly applicable, as we saw. And that scientific publishers do claim their copyright and sometimes their database right on the content of the database. So the result is the text and data mining right now, currently, is not allowed without the prior authorization of rights holders. So, and getting authorization, well, options are either you license directly with publishers, but if you're a scientist, it's undoable. Anyway, first of all, you need countless permissions for countless database holders or copyright holders. And that's provided that they would grant permission to do text and data mining, which, well, currently it's about half and half. Half say no, but the biggest say no, and the smallest say yes, basically. Other option is to go through a collective rights management organization, but so far, this is not a mandate that has been given to the collective rights management organization. So they offer themselves as the way forward. They offer themselves as the solution because they can be the intermediary between the scientists who want to text and data mine and the publishers. But it also entails paying a fee because there's, That's
what they are about.
That's what they're about. Or another solution would be to introduce a new exception in the Copyright Act. And then you have, well, you have a whole discussion at the European level, and that's why it burst out at the end of February and March, because it's way too tight. So now, just to finish this last bullet point, the current policy of many publishers, especially the biggest ones, is to prohibit text and data mining, or to set strict restrictions. So, and well, this is information that I gathered from presentations made here and there, but the biggest, as you see here, the biggest publishers actually prohibit text and data mining. And you can add also, I looked at Kluwer Law International and also prohibited, and those really are the tools with which scientists work. And this is really in those databases that you hope through intelligent query to really gather a wealth of information. So, but it's explicitly not allowed in those databases. So the discussion really flew out the roof at the European level. And one of the reasons you may have seen right before Christmas in December 2012, the European Commission came with a green paper and said we're going to look at 4 different areas where copyright law is more problematic: cross-border access of cultural works, user-generated content, and audiovisual works with cultural heritage institutions. And the last one was working group 4 is about text and data mining. But the whole effort of the European Commission is to bring the stakeholders to one table and to have them discuss. However, the initiative is called Licenses for Europe. And, well, I see people nodding. Yeah, the problem is that this is way too small, but basically what they want is to bring the parties together to allow them to conclude contracts with each other. So there was a reaction to this because scientists and groups, you know, civil groups and other stakeholders who went there. Thank you for being here, yo. Goodbye. They went to the table and said, well, no, this can't go on because we want, what they want is this. And the first bullet point is really very important. They want to be sure that all evidence, opinions, and solutions to facilitate the widest adoption of text and data mining are given equal weighing and that no solution is ruled out from the outset. Meaning, in other words, that they don't want to be restricted only to licensing practices. They want to discuss fairly and openly the possibility of introducing an exception or limitation in the Copyright Act. But this has been consistently thrown off the table. It won't be discussed. The Licenses for Europe, under the auspices of the European Commission, is only there to talk about license practices and licensing options. It's not there to discuss exceptions and limitations. And as a result of this, well, I mean, they also have 2 other points of contention that they wrote in their letter to the European Commission. Basically, if I go back one, you will see, this is the Ligue des Bibliothèques Européennes de Recherche, LIBER, you may know this, of course. They were the porte-parole, they were the voice for all the groups who were dissatisfied, and they wrote the letter that others signed, and I also signed it as a scholar in copyright, because the reason why I signed it is that I wanted a fair dialogue, and that licensing, if you look back, licensing directly with publishers is impossible. It's an impossible burden to put on scientists. Licensing through collective rights management, well, also always entails money. And when you do research for non-commercial purposes in any field, you don't want to have to pay a license. Or it has to be discounted somewhere else than in the pocket of the scientists. So, also a second bullet point from the LIBER is that they really want transparency in the process. And this, from experience, is something that such discussions lack drastically. discussions of this type at the European Commission are not transparent. And then the last bullet point they put forward was that they wanted really the DG Research and Innovation to be part of the talks. Because when they went for 3 meetings, there was never anyone from the DG Research and Innovation, but the only DG Internal Market, DG Connect and Education, but no representative of the research organizations and the researchers anyway. Now, there came a response from the European Commission, but the response was basically, well, exceptions and limitations are discussed in another forum. We're discussing licensing. DG Research is invited all the time, but it's their choice not to come. We've heard other views on that. And they didn't say anything about making documents available more than what's to be found on the website. So basically, it was a rather colorless answer. And the reaction was that most of the participants who were dissatisfied decided to withdraw from the talks. So there was one meeting last week that took place with all these institutions no longer present at the talks. So it's a gamble. It's a gamble for those institutions who decided to withdraw. They make a point, of course, and I support this point, but the danger is that the talks will keep going and that there will be a result with which you're not satisfied at all and that you'll have to live with it. And that you had no say or no input against it while it was being negotiated. So it is also, you know, the danger of withdrawing to make a point. Sometimes you lose more. I don't know. We'll have to see. I didn't hear yet what happened last week. It's also not obvious on the website of the European Commission. They usually post on the website, if you're curious. You can have my presentation at the end. I hope it's clear enough, but otherwise you just Google in licenses for Europe and you get the website of the European Commission. So they publish the presentations made during the meetings, and they publish conclusions that are written up by someone of one of the DGs. And that's it. But this also means that the discussions that are now taking place, there's no more balance at all at the table. So the only publishers will be present from now on, and or collective rights management societies. So that's a dangerous development. There's one good news in the horizon, is that the UK is very active with text and data mining, because they also see the wealth of information and the importance of doing text and data mining. The UK has been engaged in a copyright reform exercise for at least since 2007, I think. They produced the Gowers Review, and then they published a Hargraves Review, and the Hargraves Review was really the starting point of a whole exercise of reforming. And so they're a bit further in their exercise. They also had an impact assessment on a specific issue of text and data mining, and basically they thought that, you know, the market would probably be able to sustain such an exception and limitation. However, they did get, counterbalanced reactions during the public consultation in 2011. But in December 2012, the UK government published its document called Modernizing Copyright, a Modern, Robust and Flexible Framework. And in that document, there is a commitment to adopt a text and data mining exception for non-commercial purposes. So now, of course, you don't adopt a very overly broad exception and limitation. You really want to allow things to happen as long as they fit within the ambit of non-commercial research. So these are some of the safeguards that might be built in the provision that the exception would not prevent a publisher from applying technological measures on their networks in order to maintain security stability, because that's an argument that also has been made. You know, the publishers don't want an exception because that will allow anyone to do anything, and they won't be able to protect their servers and their databases. Yeah, well, so during. No, well, because it hasn't been adopted yet. Now we're at the stage, and that's already 6 months ago. Time flies. They adopted recently another legislative text, but to deal with orphan works. So I guess that was more urgent because there's a deadline to implement a directive on orphan works. The deadline is 1st of November 2013. Text and data mining, I guess they still want to take their time to really do it, because also they would be the first ones. Not only would they be the first ones, but if you put it in a European context, as I said before, the Information Society Directive contains a closed list of limitations. This limitation would go beyond that list. So, and the UK said, well, we don't even look at what others do. We don't really care what Europe says. We want a limitation. I think they're very courageous. I have an idea of what kind of reaction they might get from the European Commission if they go ahead with adopting this limitation, because they would certainly get a letter from the European Commission saying that they're not in compliance with the European copyright framework, that they would have to amend or repair or adapt. So they're brave, but they see, you know, they see the point in allowing text and data mining. Now, they also say that the exception would not prevent publishers from offering additional services, of course, and the exception would not allow redistribution of the primary works of substantial parts of those which would remain restricted by copyright. But because this is also one argument that's always being put forward by the publishers, saying, well, we're afraid that, you know, if we allow text and data mining, that the content of the database, that the articles will be just, yeah. So, of course, now they have to find the proper wording to have these safeguards built in, and that's linguistically and drafting technique is very complicated. You know, you give in one go and you take back in another, and since there's no model to build on, there will be brand new provisions. I guess I can explain why they take their time. And then the last slide is the way forward. Now, some arguments that are being put forward to support allowing text and data mining is that using technologies to find new relationships between facts does not undermine the primary market of access to research works. And that's I guess, something that publishers deny to see. They are afraid of their primary market, but they're basically afraid of any new change in their business model and any change in the way to carry out research, or, you know, if you're in another context, anything that might affect remotely their business model. But text and data mining does not affect, you know, the value or the market value of individual articles or magazines. They will always be purchased by libraries or by individual researchers. It should not make a difference. And text and data mining have the potential to deliver significant public benefits in terms of increased research at lower cost, or finding new information and discoveries and making links. And that's also what Nelly Cruz also recognized in at least one or two public speeches that she made. So one way forward in science is to allow the use, as you all know and as you all do at the CGDH, of new digital tools to get access to this wealth of information. Problem is that, as I gave a portrait. The stakeholders and the views are very polarized. Nothing new in copyright law. They're always very polarized. Whether you talk about films or music or publishing, they're always polarized. So it will be a matter of finding the middle ground somewhere. I'm just not convinced personally that licensing is the issue, or at least, the solution. And I would, of course, you see me coming with this solution. I would favor an exception and limitation, but within the bounds that are strictly necessary to allow proper scientific research on a non-commercial basis, but without affecting the business models of the publishers. But that's a bit different and difficult. So this is the contents of my presentation. Thank you very much.